Okay, we are now reconvening after a short break for some technical difficulties. So we'll wind out all those issues. I think you still with you, Mr. Baxter, or yeah, Commissioner McNally might have had a question.
Yes, this one in your summary ended earlier, talk about key changes recommended. D refers to inclusion of new objectives to ensure supplement affairs in a manner that is supported by additional infrastructure. Two questions. One is which additional objective is that?
Yeah, sub 01.
Yeah. So then, the second question is, how do you see that objective being managed? Is it an economic impact assessment or a business case? How would someone subdivide the proposing staff manage that?
Yeah, it's just like a high level objective. Just yes, yeah, then implement by the policies after this kind of.
So we would get more urban environment.
Yeah, yes.
Okay, well, thank you very much for that presentation. Anything else to add? So, in that case, we'll move on to our first submitter, which is Ms. Lyndon Woodward. I think I can see you over there, Ms. Woodward. Please come up and have a seat. You also Thompson Survey Limited. That's Mr. Thompson. You think together? Or is it two different?
No, similar.
I think usually you'll come up, Mr. Thompson, and just follow on because I think they're covering similar things, aren't you?
Yeah.
Okay. Do you have anything to hand out to us? Or
No. I don't. Mr. Thompson might.
Yeah. Yes. Thank you.
Yes, the survey is interested in the Subtitles chapter as expected. So,
As it should be. Morena. And first off, may I just say what beautiful venues that I is expecting everything in here.
this is the fourth one we've tried to convene for one month. We're making this the third round. It's a real long.
It is.
A number of years.
That's good. So no, I haven't brought along anything extra today, and I'm only going to talk to two matters. And matters that I'm talking about really were in my written submission. So, to one of the information. So, firstly, I just want to return to the raw production minimum lot sizes. I think at hearing 9, I said that I believe that you procedurally incorrect in addressing it at hearing 9 out of context of all other subdivision matters. And I hold to that. It was the wrong time to discuss it. It should have been discussed in the context of other subdivision matters. And then to read a lengthy 42A that effectively just dismisses it as if it has been dealt with earlier is again procedurally incorrect. It's very disappointing to see that approach taken. So I'm going to talk to it again because this is a subdivision hearing. And it is effectively a lack of diversity, if you like, lack of choices, lack of any understanding of the environment, of people. We've already acknowledged that only a very small percentage of the rural zone is highly productive. The rest is not highly productive, by whatever definition of highly productive. Already acknowledged that it is a diverse zone with diverse needs, diverse characteristics, and yet you sit there and treat it all the same. Anything, just close it shop and say, no, that's it. We're not going to revisit, but we'll add a few more words about land because we're supposed to. Not good enough. Haven't looked. We haven't listened. Certainly haven't seen. So again, I beseech you, please, to look at putting some extra options in there. What if the person who wants to retire on their property? It's not highly productive land. Oh no, sorry, most cases they probably can't do that. What if the rural family who wants to provide some kind of equity for the next generation? Again, on parts of the land that are not particularly productive. Oh no, make a vision for that, go away. It's just not taking heed of the needs of the world. I don't know how else to say it. I just feel hopeless and useless in saying it again and again because we're not listening. Simple as that.
Well, we haven't made a determination yet, so we're happy listening. Yeah, I was presenting evidence hearing 90 people presenting on lot sizes there. So they obviously, a number of people popping in that we were talking about lot sizes and we see quite a
and certainly I'm not, I'm not condoning and I wouldn't want to see wholesale cutting up of farms. That's not what I'm talking about. I'm talking about the options that can be provided for people.
Yes. We're certainly acutely aware of those issues. It's and definitely reassuring you that it's not, we haven't not been listening, we haven't been taking in regard to it. I'll talk a little bit louder.
Should I try to continue in a loud voice or would you like to wait?
Tried it before, and the audio just doesn't pick it up. It's just too much noise. So it's all just. Yes.
Captions working well. Oh, I don't think it's coming in.
I think we're using off of it now. So, yeah, so I mean, yeah, we have been listening. We remember that evidence. We haven't made any determinations yet. We really wanted to hear all the evidence. We knew that there was going to be this crossover between subdivisions and particularly the rural production. So we're certainly aware of those issues. They're still very much live in our mind.
Theory, over there.
obviously you've looked at some of the changes, not just to the rural production, but to some of the other rural lifestyle zone. It's more opportunity within that zone. And I think the rural strategy is intended, this is what my group has been re-articulating what the officer said, is that it's using the rural lifestyle zone to more enable the subdivision that would otherwise expect them in the production zone. I know that they are in different locations.
Yeah, and I think when I addressed you in the slide, I said that there needed to be more land zones for rural lifestyle.
Yes.
Of course, that's a big exercise.
Well, we've had some requests for some increase in rural lifestyle zoning, and that's still live as well. And I think it's 8 hectares as a discretionary activity. If you have a view.
Rural production?
Yeah.
I don't even see the logic for 8 hectares as discretionary, sorry. So I prefer 4 hectares. Seems to have been tried and true over time, seems to work. I just want to see more options as a discretionary or not. You clearly don't want to introduce a restricted discretionary category into the exercises. Make that clear in all the reporting, even though there's merit in doing so. So I just need to see more options there. To my mind, we should be encouraging self-sufficient living in the rural zone, where it's not taking away the highly productive land for highly productive use, and where it's not coming up into my farms. There is massive scope in there for self-sufficient, sustainable rural living and lifestyle opportunities. Open your eyes and see those, because there's just so much opportunity, and it's just such a good way of living. And if it's self-sufficient, you're taking the pressure off the council that can't infrastructure. I'm not quite finished anyway. Sorry. The only other provision I'm going to talk to, there are lots of other submissions by me, but the only other particular provision I want to talk to is the so-called environmental benefit subdivision rules. And I still absolutely fail to see why something that's got such a basic, simple concept, which is the protection of the environment, I get a bonus. It's simple. Very easy. So why make such a convoluted, complicated, provisional, caveated, ratioed? Why make such a meal out of something that was just so basic? I'm going to protect the environment. I get it. And how big the bonus part is, it doesn't matter. How big the balance is, why should it? The basic concept is exchange for protection of the environment, you get a bonus. And the other thing I'd like to draw your attention to is the inequity of this. Property 1, 200 hectares here. 10 years ago, that landowner decided they would protect the 10 hectares of broadleaf photograph provisions forest voluntarily, not part of any consenting process. They put it into a protected property. They fenced it. They look after it. It is now beautiful, brilliant habitat. This property over here, the same size, same area of broadleaf photograph, not protected. Stop get into it. It's there, mediocre, would really do well with some protection. This person, having already protected it 10 years ago, gets nothing. This person sees this clause and says, oh, if I put a fence around that and tell you I'll protect it and manage it, I get a bonus. What about this person who's given that bush 10 years head start with habitat? There should be no difference. So as I said in my original written submission, it should include any area that has already been voluntarily protected by that landowner outside the consent process. That needs to be written.
I was saying already legally protected, but not benefit. So,
Yeah, no, that's right. No previous benefit. That was all of my original written submissions.
I haven't really heard the questions.
You only been around like that for 60 years, but thank you. I haven't made any decisions on it either, but you've followed a few issues. What are your solutions?
Well, rewrite that particular provision. Environmental benefit subdivision.
I think that,
Yeah.
But I mean, that's easy to fix. I just put a fence down, go and get them fence it. I mean, that's how ridiculous it is. I get it.
Yeah, you get perverse results.
Easy to go well. Push scrap, all the is an provision. But you've highlighted, as I said, issues. What are solutions? What are your thoughts on it? What's the minimum lot size that you do?
You always want to have a standard minimum lot size that people can look at and know with certainty. But at the same time, especially if it's discretionary subdivision, there's so much opportunity there for some nuanced assessment and conditions that could be applied to different circumstances.
Well, you mentioned a couple of those, succession planning as well.
Yeah. So
I don't want 4 hectares. I really want
smaller.
Well,
I mean, I don't think I said in my original, I don't think I said in my original submission, but you've got all these 2 hectare lots around the place now as a result of the existing cooperative plan. You know what? I'd suggest you cut those up. I'm not good for anything else anymore. That,
I'm only one person. I guess my point is we've heard and we're listening. No decision been made yet, but it's I prefer to have
so in my written
Specific.
submission,
specific. This is what we
so in my written submission, Councillor McNally, sorry, Commissioner McNally, I suggested keeping in and reintroducing the concept of the retirement lot for the small 4,000 hectare lot. Personally, I think that should be 5,000, but in that realm, and a finite number. You certainly don't want to see it before that either, but a finite. I also think that because of the nuances and the differences across the rural production zone, there needs to be a discretionary activity providing for smaller size lots than 8 hectares, and even for 4 hectares, where the land is definitely non-productive. In other words, it might be too rocky, it might be so steep, it might have the right characteristics to be used for productive. So why not have it for rural lifestyle size lots, but not for rural lifestyle?
So there you go, that specific report.
Yes, there's reports. Not difficult to do. I mean, we're going to have to radically update all that historic land use capability mapping anyway, because it was done so many years ago and done so broad brush. And even if it survives, I don't even know what this coalition government is going to do and know. But there's so many differences in the zone. That's why discretionary is the appropriate place to introduce these options. Council has discretion. Discretionary is about. Don't make it out of reach. Don't shut the door.
So we heard you. And so the chair.
I'll throw one more question in. If we were to make it discretionary, I'd be happy with the recommended policy framework as the basis for evaluating. Or would we need to revisit it and make sure that there are some more directive avoid restrict type languages in there so that the discretion is there to.
I think respect is almost the other way. It would be introducing more terminology like to enable and provide for, rather than avoid and protect.
So you would, so if we were to make it discretionary, you have a look at the proposed policy framework, see how discretionary should be worded in that policy framework.
Doesn't particularly.
There we have to follow. Yes, if we were to
It has to be more nuanced in the objectives and policies.
So you'd want the policy framework to be more enabling. The word production. Something. Okay. This whole question of retirement lots, this has been a mechanism that's been around for some local areas. It really was quite popular in 80s. those of us who were around here. And then it fell out of favor because, you know, granddad would get his one hectare farm in the school, like this, when he got, and 3 weeks later, it was off and told him when the house is on the market. And so my question to you is, you know, that was obviously that issue. And then, of course, along comes another granddad who also wants a retirement lot. And each generation creates a site. But that was one reason why I think. But my question to you is this: why do farmers need to retire on an alienated parcel of land? Why couldn't they just retire on a large property in another development? And is one of the potential solutions to this to allow more a retirement dwelling? Why does the answer have to be an alienated parcel of land?
I think the point I was making is that, you know, the term retirement lot is perhaps an unfortunate term. I don't see anything wrong with 2 or 3 or 4,000 square lots taken full stop. But anyway,
I would say
I know it's the terminology that's been around.
But this is the thing is that I don't mean this pejoratively, but we get this sort of slightly emotional argument, which is, like my son, I don't want me hanging around, you know, and you know, it's just, he's going to live on my land whilst not having to have the burden of owning and running a farm. And that's a strong argument for those reasons. So that's why I raised it, because they use that argument is still around.
What we get more of is a subdivision surveying. What we get more of in terms of my clients in particular is they may have 2 or 3 or 4 offspring. Some of whom might want to be on farm, some of whom might not. And so a lot of the time they're coming and looking for a way of creating separate titles to introduce those offspring into the property market. It's not to say they're going to stay, but it is an introduction, stepping stone into them having their own equity. So that comes up quite a lot. And it is emotional because it's the next generation. No denying.
So that's always an argument that says we help solve urban housing shortage by allowing some small lots of people to have a full product.
I see nothing wrong with a limited number of small lots in rural area amongst farms.
And I suppose, again, I'm just playing with advocate, you're testing, facilities. Your council say, well, we've allowed a lot of residential zone, really, for its purposes, smallest lot we can get service. There's lot sizes down to some of the
2,000
square feet. So really on the edge of what you ever consider rural. Subdivision, which have become more enabling. So you guys don't think that's enough?
I think you're just missing an opportunity to allow people to live in the country.
Yeah, but don't those other zones provide that opportunity?
Not living in the country. People to the town, haven't they? So why rural residential is in a rural environment is still the old.
You don't see the rural residential zones in rural. There are spaces. What are the rural lifestyles? Yeah, that is feasibly large enough to undertake rural production.
Feasibly.
I hear evidence all the time.
Some might be, some might not be. That's the whole thing about our rural area is the ability to produce varies so widely.
I suppose your concerns about rural lots that will run away from the
I think council should be encouraging self-sufficiency as much as it could because council struggles to provide its infrastructure and will continue to struggle to provide infrastructure.
Thank you.
Thank you.
Check.
Thank you for listening.
Yeah.
I'll just slip an eye on the one.
How many times do you have to read it before you understood it?
I think it's pretty good to me. It's based on similar.
Yeah,
I mean, it is. I'd like to understand better your concerns and what it's like.
but I wouldn't recommend a client of mine try and use it. Sorry, it's just not hitting the mark. Why limit how large benefit bodies to think or how small? Why limit a big balance system? Where's the rationale?
So it's about that balance as well.
Yeah, where's the rationale? Why limit it to only newly offered? As I said, why not look at that that's already protected? There's just things in it that seem to unnecessarily pose rules. Which brings them up.
This is actually what I think. But it's already been years ago. Because it is a lot of this clarification from starting to get first.
It does.
It says you can't. Which part of it?
And certainly, yeah, that's right. You can't come back and have a second go because you've already benefited from it, or it's been a condition of the resource consent that's required to protect it. That's my problem. That's done. Use that. Where someone has done it, pick a volunteer, no consent.
I think this will come up in hearing just a little. Do you report this issue being addressed? I can't recall this question details. I can go back to the line and see if it's in there.
Yeah, I don't recall specifically here in mind, but not all mechanisms are created equal. For example, I know
if it's observed, that's hard to understand.
yeah,
So that's at the top of it. And then you've got the
QE2, you can, it's not a straight out preclusion of grazing or certain routes that is the same. So you're not necessarily dealing with that in terms of protection. That's when you would go through perhaps a process of reviewing whether since we can get closer to an apple with an apple, for example. So in terms of a straightforward provision, that requires, I guess the first gate is much simpler to go through where there is no other complications to consider in that matter. But it's not really clear in instances where they say we've done that.
I certainly have experience with someone with the kind of experience.
It's a quite the provisions are certainly have been maintained for a very long time, and people making those decisions should be making informed decisions.
It's for the open.
It's similarly, like there are other options within the framework that enable consideration and management plan type frameworks as well. That you could perhaps do and we'll consider.
I'm just wondering whether, I mean, and on the concept of which that hearing see if it's possible land that's legally protected, but if that means, but no benefit has been associated.
Particular and done that for reasons other than getting subdivision. And you're showing good pace, surely you should be.
It's that recognition.
I mean, there may be unintended consequences if you do that, and or some may have tried, may have been tried before, and we run into a whole issues with regards to Particularly me. And that's the question. Ensuring you're
That was my understanding of some, but that was some fenced off and protected.
And managed.
And yes. What's got open. What's been done. So that I think is what. So I don't follow that.
and we have reported them. I think they're-
I think it was in the biodiversity. Like, 100% sure myself.
In that chapter, you can't bear a total number set size of it. So it's another. So it's building. What's environmental benefit bonus concept?
Thank you very much. That's been an interesting discussion. Thank you, Mr. Thompson. So we'll hand it over to you.
I won't, Linda's covered pretty much what I was going to try and say. She's better with words than I am, but I'm pleased to hear you say that the subdivision rules are open. Like you have a man of your mind, says you. But in the rural area, there needs to be the opportunity to have a place for people to live. Like Lily mentioned, there's lots of 2 hectare cycle, small plots that are there already that are never going to be farmed as part of farm. There's huge opportunity for those properties to be further subdivided. And that's not wasting the environment. Councils, or this our council, cannot afford to provide infrastructure, sewage and stormwater. So we want to provide places for people to live. The council cannot afford to provide infrastructure in town, yet they're going to say we're going to stop you from going to live in the rural areas. A home in the rural location is delightful. It does not have to waste the environment. It's, as Lindley pointed out, there's only a small percentage of the land that's highly productive. It's a massive percentage of land that has got some reason for not being highly productive. That is ideal for a housing profit for somebody to build a home and reside there. I'm not wanting to open the floodgates, like you mentioned the retirement lot. The previous district it provided for a property. I called it a retirement lot, but if the title was older than 5 years, you could create a subdivision. And I think 4,000 square meters was the minimum size. A fellow Dr. Ian Young, many years ago, he ascertained that in the rural environment, to provide for on-site airport exposure and the house location and so forth, 3,000 squares was the minimum suitable size. Then he mentioned 5,000 square meters. The district plan that we've received, that we're objecting to, has no provision for this. It only allows, very large ones. There needs having the opportunity for residential rural lifestyle block where people can have a good vegetable garden and provide for their own life in the rural area. it provides for people and it provides for the community. And so I ask you to make provision in a restricted manner to allow for people to live in that environment. And the 5-year lifestyle record retirement block, it worked okay because a title had 5 years old. So again, it wasn't a wholesale subdividing, it was in a controlled manner. So basically, I'm just asking you to make provision.
Have some more to say?
Yeah.
Thank you. This is Adam here. Thank you very much. Very well.
Thank you.
Next submitter is the War Forest and Bird Society New Zealand. Mr. Williams has been sitting on the line. There you are. Good morning, Mr. Williams. Good morning, Mr. Williams. Can you see and hear us?
Good morning. I can see and hear you. I've been having a few issues with the audio still, but hopefully you can hear me. And
Yes,
I'll try to.
We received your legal submissions. So we have them in front of us, but because we received them just today, we haven't read them. So it would be in your hands to read them to us.
Oh, I'm very grateful for that. Thank you. Yes, I was intending to send the submissions at the end of last week, but unfortunately I was unwell. So yeah, I'm grateful to AK for handing those to you so quickly. I'm sorry you haven't had a chance to look at them before the hearing. Thank you very much for letting me attend remotely. Obviously, I'd much rather be there in person. It makes things much easier, but I couldn't be. It looks like you've got a marvellous venue there today. I would have liked to have been there. Okay, so I will try to take you through my submissions then, and I'll use those submissions as a template for my submissions here today. So Forest and Bird did make an original submission on the subdivision chapter. I think that has possibly been overlooked in the Section 42 report, but I don't think anything much really turns on that. I'm here today, and so that's all okay. Our concerns, you won't be surprised to hear, are relating to the protection of areas of significant indigenous vegetation, significant habitat to indigenous fauna. And it's been a theme running through Forest and Bird submissions throughout this district plan change that, as I'm sure the panel will be very well aware, what's occurred is that there was an intention to include a schedule of identified SNAs that has then been removed from the proposed district plan, and as a result, Forest and Bird is very concerned to try to ensure that that doesn't result in gaps in protection for these areas which are no longer identified specifically in the district plan. So it does create a bit of a problem for the plan, because originally the notified plan did rely to quite a large extent on that schedule of SNAs, which is no longer there. So the starting point in terms of subdivision is, I hope it's not controversial and you will accept this, that subdivision can have significant adverse effects on indigenous habitat. In particular, it creates potentially fragmentation. So if you're breaking these significant areas up into separate lots, then that creates man-made boundaries. other permitted activities that can occur along those boundaries and within the separate lots. And residential activity also results in other potential adverse effects, such as domestic animals and pests. So if you place those close to significant areas, then that can result in adverse effects on those areas. The notified plan relied on, as I understand it, Rule 17 to address some of these potential effects. So Rule 17 related to subdivision of a site containing a scheduled SNA, and it created a discretionary activity status where a site did contain a scheduled SNA, and there were two criteria in order to be able to fall within that activity status. And the first is that the site should be outside the coastal environment. And the second is that the subdivision does not divide the SNA. So that was Rule 17. And in my submission, that was a very important rule because it prevented the fragmentation of SNAs as part of a subdivision. Now, that rule is now proposed, as I understand it, it's recommended to delete that rule. And what that means is that the plan will rely on policy 8 and the 3 different rules that are identified in that policy in order to manage the effects of subdivision on significant areas. And our concern is that that approach isn't going to achieve the appropriate outcome of protecting those significant areas. And I'm sure I don't need to emphasize really, but I will mention, you know, that the fact that there have been policy changes in terms of, you know, how the plan should deal with SNAs, which have been made by the current government, that doesn't affect the fact that the plan still needs to give effect to Section 6C and Part 2 more generally, and also, of course, the regional policy statement, the Northland Regional Policy Statement, which also contains strongly directive provisions about protecting these significant areas that meet the significance criteria. So those are still matters that so why is it that I'm concerned about the current approach? Well, at paragraph 7 of the submissions, I've referred to subdivision policy 8. I've said it provides for 3 alternatives, and that's because A to C they use the word or, so only, you know, you just need to meet one of those, fall into one of those categories in order to go past the avoid policy in the header there. So you can be either sub rule 6 or sub rule 7 or sub rule 3. And then so each one of those needs to be able to ensure that the significant area is protected and not fragmented. And that doesn't seem to be achieved by the current wording. So beginning with subdivision rule 6, it's paragraph 10 now of the written submissions. There's no requirement in that rule. Just go to rule 6 on my screen, hang on. Okay, so sub-rule 6 is the environmental benefit subdivision. I've said that there's no requirement to avoid adverse effects on existing yet to be identified significant areas, for example, against fragmentation. And at least my reading of that was that an applicant could fragment, split up an area with these significant values that meets the significance criteria in the RPS as part of an environmental benefit subdivision. So what I mean by that is that they could just carve out a part of that significant area to protect it and then just leave the balance aside without having regard to the fact that it's the entire area that meets the significance criteria. So there's an element of sort of an arbitrary thing introduced whereby a landowner could define the boundary without reference to the significance criteria. And then at paragraph 11, I've referred again to the implications fragmentation may have. So, potentially vegetation clearance for boundary fencing or just maximum areas of indigenous vegetation clearance within a single title, which I think is how the plan is likely now to manage vegetation clearance in the absence of SNAs. Is just a permitted level of clearance, which is set at a level which it is hoped won't have significant adverse effects. But of course, once you've divided it into two properties, you're essentially doubling that allowance. And there also doesn't appear to be any requirement for buffering around the SNA or the significant area that's being protected. And then I've said more fundamentally, Rule 6 doesn't appear to recognise the fact that a significant area is an existing state of the environment. It doesn't only come into existence at the point that it's assessed, described and legally protected by the applicant. That's really the same point, that we need to be looking at the significance criteria based on the environment as it is, not just at the line that's being drawn by the applicant in its application for subdivision. Moving on to Rule 7, which is a management plan subdivision. So this applies to applications for subdivision consent in the rural production zone or the sorry, hang on. The rural lifestyle zone. Sorry. Yeah, so the rural production zone or the rural lifestyle zone that are accompanied by a subdivision management plan, which complies with Appendix 3. The criteria in Appendix 3 require a description of the existing site characteristics, including areas of indigenous vegetation and habitat of indigenous fauna and any notable trees, but they don't currently require an assessment against the RPS significance criteria. The proposed management measures must include measures to protect, manage and enhance indigenous vegetation and habitats. But again, there aren't currently any specific requirements relating to the protection of areas that meet the RPS significance criteria. So it doesn't go far enough in my submission to actually protect those areas that do meet the significance criteria. And also the criteria are limited to the provision of information. And although subdivision under Rule 7 would be a discretionary activity, there don't appear to be any proposed policies that would direct the decision maker to protect significant areas against adverse effects that are caused by the subdivision itself. So this rule could result in more large-scale residential subdivision, bringing further risks in addition to fragmentation of introducing problem pests, domestic animals that predate native fauna. This could be a particular issue where there's kiwi habitat, for example. Finally, subdivision rule 3 allows subdivision around an existing allotment. Again, in my submission, as currently worded, this rule doesn't protect or buffer SNAs or prevent fragmentation. And as noted above, dividing significant areas into separate legal titles is likely to have adverse effects, which wouldn't be appropriately managed. Right. Then moving on to subdivision policy 9, which is for subdivision in the rural lifestyle zone. So the policy there is to avoid rural residential subdivision unless the environmental outcomes required in Rule 7 are achieved. And here I've said that paragraph 19 of the written submissions policy 9 encounters the same problems described above in terms of protecting significant areas. Although it refers to the environmental outcomes required in Rule 7, there do not appear to be any environmental outcomes required by Rule 7. There are only information requirements. And even though, yes, sorry.
We've actually put this question to the council officers already. So they'll be coming back with a response to that. But I think, it's the same question. We asked for policy 8 as well. I think the interim answer that I think we're working with that is that it's really a reference to Appendix 3, but we'll get something more about that from council officers tomorrow.
Probably to add to that, Mr. Chair, is we haven't, as you know, we've avoided cross-referencing quite substantially through the plan as well. While the subdivision focused policies, like the Indigenous biodiversity chapter provides a range of direction as well that would be called upon.
There's also some other evidence that we're hearing tomorrow that concerns that policy 8. And that suggests a bit of wording, so we're looking at that as well. But yeah, we're aware of the issue.
Okay, thank you. I appreciate that. Okay, so well, and I think I did hear reference there to the eco chapter. Paragraph 20, I've noted that the problems are exacerbated by what I understand to be the recommended deletion of policy 4, which would have required expressly directed management of subdivision in accordance with the eco chapter. So I'm not sure if there's going to be some other provision, but I saw that deletion as being an issue because that link back to the eco chapter appears to have been removed.
Are you referring to the biodiversity chapter?
I mean the biodiversity chapter, so yes.
This is a chapter.
Yes.
I don't think that's what Mr. Williams is very reasonable. But those provisions still apply, correct?
Correct.
So even if there isn't a specific policy in the subdivision section that concerns significant areas of indigenous vegetation, the whole the biodiversity objects and places will still apply, notwithstanding.
Okay. Well, that's yeah. Yeah, how clear the link should be possibly for the benefit of plan users, and also this issue. I don't know where, of course, the biodiversity provisions are going to land, but there was similar issues in that chapter which arose from the removal of the schedule of identified SNAs. So it's the extent to which those biodiversity provisions are now able to protect unidentified or unscheduled, yet to be assessed significant areas that do in fact meet the significance criteria. Okay, so just then in conclusion, I've said that the recommended changes to the subdivision chapter wouldn't enable the council to meet its statutory obligations under 6C Part 2 and the Northland RPS. And I've suggested that to address this problem, one option would be to include or reinstate a version of Rule 17, which requires an assessment against the RPS significance criteria. I've called it an SNA assessment now. So these submissions are slightly, the terminology is a little bit inconsistent, and I apologize for that. But it would be better in this context, I think, to talk about an assessment against the RPS significance criteria, because those are the higher order provisions which the plan certainly does need to give effect to. So an assessment against the RPS significance criteria in cases where land being subdivided may include a significant area, and then to require those areas to be protected if they are identified. And I've suggested that council may be able to use the information it already holds to determine whether an area is likely to be a significant area. I'm conscious that quite a lot of work has been done on this. So there is information that the council should, I would have thought, be able to refer to in terms of making an assessment of whether an initial assessment, a sort of a triaging of whether a full significance assessment is likely to be appropriate, and perhaps some sort of trigger to shift the activity status where appropriate to enable that assessment to occur. So thank you. Those are my submissions. I'm happy to answer any questions you may have.
I'll ask a few already, so I'll go around the other ones and debate first.
It's really clear, it's continued to us, and it's raising some important issues. So I'll be really interested to hear what the staff are saying. Thank you.
Yeah, so from me, just again, we're aware of the issues regarding policies. And we're seeking some clarification on that. And look at that tomorrow when council was their responsible evidence, or it's in their personal. So we certainly alive to some of the issues and prayers.
I'm grateful for that indication. Thank you. Yeah.
Thank you very much.
I'll just, you mentioned the objectives in your submission. I guess are you comfortable that the objectives in the subdivision chapter are specifically in the right direction to travel for protection? I was looking at number 2, objective 02.
Yes.
Is that?
Yes, that's I support that use of terminology to replace the SNA terminology, which has become so problematic. It's really a question of whether the policies and rules do actually manage to implement that objective.
Any clarification issues, officers? Well, thank you very much. Good to see you again. I'm not sure we'll see you at the last hearing next week. So if this is your last presentation, thank you very much for your attendance and presentation submissions throughout this process. It's been
Thank you.
Greatly appreciated.
Thank you, Chairman. Thank you. I appreciate that. Okay. I hope you have a good rest of your hearing. Yeah, welcome. Steve?
Perfect day. Bye.
Yes, I will.
Everybody will ask you are having some issues, so does it take a time to get things up and running? So all your evidence is going to be by your PowerPoint presentation, is that correct?
Yes, supplement my mission.
Now it's quite delayed, Mr. Palmer. So
Do you want to just
yeah, I can do it from here if you like. Yeah, sure. No problems.
Okay, I think we might. My name is Ian Palmer. My nation is in support of my solution 556.
Oh, there we go.
Initially, I thought this would be a submission that would be held to be the kind of the definitions, the hearing the definitions. But I think maybe quite more appropriately we put it under subdivision. And it is a bonus essence of round one, if the right words being used, like in subjects one. Subjects one, of course, is the subdivision minimum size requirement standard, or what might be called the I call it the fragmentation standard. And I'm suggesting that it would be more appropriate that standard be talk about the minimum site size rather than lot size. So, excellent. So the Secretary to a report rejected the submission, and the key text, the rationale for the rejection is here's in the next slide. I think,
There we go.
yeah, and particularly the highlighted word in yellow, I think the essence of the rationale. I'll come back to that rationale response to it towards the end, if I may. But we go to the slide. So, and on the next one, excuse me if I'm look like I'm telling you how to fry eggs, but just if you're important we're all on the same page in terms of the different different terms, different classes, if you like, of fragmentation, all of which are used in different ways in the proposed district plan, or in the associated plan. So a lot and a lot, I think, are very appropriately and well defined in PDP, particularly the RMA. Those terms, one other reference that 525 times in the notified plan. I suggest that you might want to look at the context of sometimes where the word lot is used. In the context, it appears to me that we're really talking about sites. Maybe the word lot sort of used loosely when actually we're talking about site, given that allotment and site are certainly not the same thing. That's as you correctly define them. And then a title and certificate title, record title, that's used a few times in the plan, not defined in the PDP, but I think we all understand that's referring to this record of title, term that's defined in the plan. That's the actual thing we know about the title. And site is, I think, is well defined in the notified PDP, and it appears many times, 2,035 times in the notified PDP. So this site is a key measure of fragmentation that the PDP is, I think, rightly concerned with. And then there's a rating unit. Now, rating unit is not used, not defined, not used in the text of PDP, but it is actually appears in the E-plan. Want to visualize using E-plan tool fragmentation of land. Unless I've missed something, you can only visualize by clicking on different areas, rating units, not sites or titles or lots. Now that's not a particular problem with regard to lots and titles, because as you'd be aware, the LINS data system allows you to identify and visualize fragmentation by lot title, parcel, options. But it does see some anomalous since science is there as before the key element of fragmentation that plans dealing with it seems anomalous that the E-plan tool doesn't allow you to actually visualize it. For example, before my permission to help myself and our neighbours use zoning hearing, when I went to our neighbour's property, they have 6 sites. When I go to E-plan to try and identify that, I'm trying to make a slide of that, I can only identify their property as one rating. Their 6 sites can amalgamate rightly wrongly into one rating. That's really just a different side that you might want to consider as a part of the E-plan. You next slide. And given those definitions of those fragmentation elements, and again, excuse me if I'm like eggs, but what we all understand that a property can be comprised of multiple ratings. My wife and I own a property, it happens to be comprised of 3 ratings. And a single rating in it can be comprised of multiple sites of my neighbours. And a single site can be comprised of multiple titles. It's not so common, but it's sometimes sites can be titles, and certainly titles can be comprised of multiple allotments, and that's very common in rural areas, including, we'll come back to this part of my examples of the problem, where a title settles a peg road. Let's not go back in history, but now create a title settles a peg road, Liverpool insists that means that title finds the 2 separate lots on the road. That's right. So the relevance of land fragmentation definitions with subdivisions. For sites, it's obviously very special and relevant and important in any district plan and post plan. And I suggest to you is because by definition, site is the smallest fragmented piece of land that can be built by the solar. That is to say, firstly, you can't sell a lot if that lot is just one of 2 lots at a time. Similarly, you can't sell a title if it's bracketed with another title. So the site price 2 titles, you can't sell one, but the site is key in that sense. So insofar as subdivision in just a planning context, rather than strict land cancel legal context, is concerned, I believe, rightly, with the further fragmentation of land. So it's the creation of new sites, and particularly additional sites, that should be, and I think is relevant. And the corollary of that is that, therefore, not so relevant whether in creating a new site, additional site, whether that leads to amalgamation or creating additional lots or titles or ratings or properties. It's not so. It's not the key thing. The key thing is, are we by subdivision resource consent application? Are we creating? Are we adding to fragmentation district by creating a new lot? Now, I've done a little. I can't say exhaustive review of district plans throughout the country. So suffice to say, there's no consistency among district plans and municipal plans. However, it seems that at least some of the more larger, more sophisticated councils have moved away from minimum allotment size towards minimum site size, or a slight refinement on that, and net site size. The net just with a discount of element of it's a right way here. And I went to the noting in Auckland, some of their predecessor district plans before the unit plan used the term minimum allotment size, but that's been abandoned in the current unitary plan and gone to minimum net site size. So as a country of mine, professor asked them what was the basis for that change, and that was after it came back, particularly I guess it was the last sentence, definition of site is narrower than allotment in RNA, allowed drafting detailed subdivision control scheme. But I think Auckland obviously in amalgamating all their going from a set of predecessor district plans into the unitary plan, presumably they could have adopted terminology one or the other, but they've thought about it and realised the logic of defining fragmentation standard in terms of minimum site. Next slide. From my experience with the subdivision resource application related to our property, I observed that, it appeared to me that the council planners, even though in the operative plan they also use the term minimum allotment size, actually take that to as if it was referring to minimum site size. In our case, on the left there is what my wife and my property was comprised of 3 sites in the red, blue, and green. So our one property, as it were, was 3 ratings, 3 sites, which had 4 titles because of historic resources imposition condition, and happened to be by allotment. Now, even though it was just a boundary change proposal, because of won't get into details, that because of the restrictive term definition that you use with boundary change, both in ODP and PDP, which if I thought about would have been another submission, suggesting that it's too restrictive. But anyway, because of the way that boundary adjustment was at the time, this application for boundary changes was didn't meet that condition, so it was treated as a non-complying subdivision. Essentially because all the new sites are less than 10 hectares, and for German coastal, the minimum lot size, the discretion, strict discretion was 20 hectares. Nevertheless, it was consented to because the planners correctly noted that no new site was created. The fact that we were creating additional allotments from 5 lots to 8, obviously the average size of allotments were quite a bit smaller, and that took about 5 years for this resort set to go through for various reasons. Not all paying into account of that, something sort of changed our details what we wanted part of true, but there was any mention that that we're creating more lots and comparing those lot sizes to the minimum allotment size standard. But all the consideration was on what we're doing in terms of sites. So it was clear to us that my plan that even though it says minimum lot size, that perhaps the plan is actually assuming what you mean. But anyway, next slide. I submit to you that there are unintended consequences in using minimum allotment size. So I illustrate that by example. So if you look in black, the track 4 case, if you have a rectangular piece of land, 400 by 200 meters, 8 hectares. If you want to subdivide that in half, you can do it down the middle, either on the long axis or short axis. Either way, you end up with 2 new sites, each of 4 hectares. One sort of elongate, 400 by 101 pack, if you like, 200 by 200. But for argument's sake, the minimum lot size to control subdivision. This hypothetical situation was 4 hectares. Either way, you comply with that standard, so no problem. So in this hypothetical case, it's exactly the same situation, but let's say that there's a paper road that runs down the middle of this rectangular 8 hectare site. And the next slide, the diagram. So essentially, it's still fixed land that's 400 meters long by 200 wide. It's actually 220 wide now because the paper road in the middle. And the starting point is it's one site, one title, but it's almost certainly, depending on when it's created in modern times, the title will have 2 lots. So if now we want to put in the resource application to subdivide that site into 2 halves, you have obviously again 2 options: do it along the long axis or the short axis. So go to the next slide. Do it along the long axis. It's you create 2 new sites. Each would have its own title. Each will have only 1 lot. But the sites, new site 4 hectares, new title 4 hectares, and each lot 4 hectares. So to meet the minimum allotment size standard, so no problem at all. However, if you want to subdivide it in the other dimension, create 2 new sites, again, next slide, that are more compact, more closer to square. This is what you have. So the new site on the left will be in 1 title, but the new site on the right will be in separate titles. But LINS will insist that because of the paper road there, that those 2 new titles each have 2 lots, 1 on each side of the road. And of course, those 2 lots, all those 4 lots are now going to 2 hectares. So it now doesn't meet the sub S1 standard. So this view, but when you're subdividing it along the long axis and the short axis, it's the same amount of fragmentation, still creating just 1 additional site. So but in one case it meets the standard, in one case it doesn't, which I would suggest you as an unintended consequence. Next slide. So going back to the rationale for not supporting our proposal, just those highlighted words, I guess I struggle with understanding exactly what is being said there. Capturing existing landholding, pending subdivision, minimum size requirements for properties not subject to subdivision. But the subdivision standard, sub S1, only applies to new subdivision. So I don't fully understand what's being said there. I suspect if I did understand it, I'd agree with it. So perhaps that rationale needs to be better explained and maybe example given to things that I have feeling it's suggesting that subdivision rules should be applied to existing land holdings, which doesn't seem to be right. And then the second part of the rationale is to avoid unintended consequences. Well, I would submit there are unintended consequences using the allotment size, but I don't think you can, I would intend or challenge you to give an example of an unintended consequence of the use of site size. I don't believe you can, but if you believe there are, then I suggest the council should give some examples of those unintended consequences that you use in site. So next slide, in conclusion. So I would submit to you that there are unintended consequences can result in using an allotment size, whereas I don't believe there is conceivable examples if you went to minimum site size. And it appears to me that from experience of the planners have in effect been treating minimum allotment size as if it was minimum site size anyway. And the next point about PC calculations, I don't have time to go into the detail of that, but if you think about it, that if you wanted to look at what zoning will do, for our commission on supposed zoning submission, our land and neighbours' land, the PC concept is employed to try and show that zoning would create more fragmentation. But you run into trouble if you strictly use your minimum allotment size, because PC calculation essentially when you're dividing an area by the minimum allotment size and dividing hectares by hectares per lot. Well, the answer must come out in lots, and then you have to compare the lots that you currently got without the upzoning, and you'll find you'll get this outcome. You'll find the upzoning creates less fragmentation, which of course is not really true, and that all comes from inappropriately finding minimum fragmentation by allotment size or site size. And then just finally, certainly some councils, and certainly Auckland, for example, where they have turned away from the minimum lot size and gone to minimum site size or net site size, and answer to my question I put to them, they report no unintended consequences or no adverse issues arising from that. That's
Yeah, thank you. That's been quite thorough. I think I understand the issue that you're wrestling with. I think it's the whole issue of using allotment size. Just very reflects the complex nature of land ownership and the various bits of legislation that apply to various definitions of what land, site, it seems to me, you obviously, I was looking through this, and I was thinking, unless the rupture was property.
there isn't.
Well, I was just going to say, is the issue primarily to you because of the paper road?
The
paper road on your property?
It's because we have the paper road that made me aware of this issue. But going forward, and it could have been an issue in the resource consent application we went through the boundary change. But as I said, it was never raised. And I think it was never raised because the planners were not looking at minimum allotment size. They were actually thinking minimum site size. And we went the 3 sites that we ended up with the same average size, 3 sites that we started with. So we don't envisage any anticipate guarantee the future, but we're not looking to do any subdivision where this issue would be a problem for us. But if anything, if you stick with what you've got, going back to our commission on zoning, the argument that you're trying to use PCs, I think if we got to the Environment Court, I'll run ring around with PC argument, you can stick with minimum allotment size. So in a sense, there's no way you tipping this submission is something, something that we want to benefit ourselves. It's really just it offended against my sense of logic, if you like.
And you're really just simply to replace the word allotment with site.
Yes. I think that you have to go through and associate with that, looking at where the word allotment's being used as well. But as I said, I believe if you look closer where allotment and lots are used, sometimes you're actually using that term loosely where you actually mean site. So, interestingly, site is a term which I think you'd agree is very important in this proposal plan or district plan. Site is not a defined term in RMA. Site is defined differently in different district plans. Interestingly, in the Auckland unitary plan, our property, because of the having lots on either side of the paper road, we've got sites that don't meet the Auckland's definition of site, whereas your definition of site, which I think is actually better, we do.
You should cross leases as well.
Yeah, I'm not so with that. But I think that part of the problem arises because if you, the definition used in the PDP of subdivision refers to the division of lot lines, which is, and that's comes from the RMA. But when you think about subdivision doing a resource consent subdivision, it sort of goes in two phases, doesn't it? The applying to council is looking at in terms of, you know, should you be allowed to do this fragmentation of land? Is that the benefit of the that applies to the rules, but is it appropriate? But then at the back end of the process, it goes to LINs, and LINs, because of their rules, they're the ones that says it's got to take a road in the middle of this new title, it's got to be 2 lots. It's not the council saying that's the way it has to be. So, you know, the subdivision process has a tail end part to it, where LINs get involved and say how the titles have to be constructed and what a LT plan should look like in the plan. I think that's sort of misleading to use the RMA definition of subdivision for this planning purposes. We really want to talk about fragmentation, but to me the better definition of subdivision versus this plan is the creation of new or additional sites. That's, I think, the better definition of subdivisions of this planning.
Okay, well, thank you.
I think the states are raising issues. It's and it will be a complex job to start by the sample and it's a lot of sample. But the only question is, have you looked at the national thing?
Yes, I have, and that was particularly unhelpful because the particular plain standard one for the what's the supported the document that they published best practice document, what's called the subdivision that the ministry published. Yeah. I can give a reference to it, but anyway, it uses talks about minimum lot size, minimum site size in the same document. They're talking about the same thing, so it's not helpful at all, and which suggests that there hasn't been enough. And as you know, allotment, certainly the way you've defined it here in the PDP, is not the same site. So to talk about minimum allotment size and minimum site size in the same document as if you're talking about the same thing, yeah. This is something I, by the way, raised with Chris Bishop's team that's working on the RMA, and suggesting that definitions of terms like site, boundaries, adjustment, etc., many terms that they're used in all different plans. There should be a national set of definitions. And why should site be defined differently in one council area for another? Why should boundary adjustments be defined differently? I mean, we often plan A2, that's got a 135-page document just on definitions, terms used in their plan. And as I say, some of them I don't think, like site, I don't think we've got that one right. So,
Let's see if there's a question for clarification. Obviously, something for you to address tomorrow, and then you might rise or anything.
No clarification, other than to say that I think a lot of the matters are resolved by section 2A, subsection 3, the RMA. So it says for the purposes of subsection 2, which talks about when things are grant, so I'll paraphrase here, and is comprised of one record of title, could be issued under the Act, shall be deemed as continuous area, notwithstanding that part of it is physically separated from any other part by a road or any other matter whatsoever. So essentially what that means is it is deemed, could be, for example, 2 lots and one record title.
I'm very familiar with that. Looked very closely. I've got a title that's in one allotment, where exactly that rule that rule applies to, that allotment has two parts to it on either side of the paper road. Because in the old days, you do that. But that's talking about when a allotment is separated into two parts, non-contiguous, that they're treated as being contiguous when they're actually not contiguous. That clause doesn't apply to when students create new two different allotments, which are separated by which are not contiguous. I looked at that clause very, very closely, and it doesn't get over that issue.
We'll have a look at that. Something like that. Thanks, Bruce. Oh, okay, well, then what? June. Two.
Yeah, until 2, sorry, it's correct. Okay, stop.
Just coming at 2.
Yeah. But, yeah, Yeah.
Stand down, stand easy.
stop the recording.